Inheritance law can be a complex and multifaceted subject, especially when it involves dual citizens. What happens to the inheritance? When a person with dual citizenship passes away, their inheritance can be subject to the laws of both countries where they hold citizenship. However, the actual application of these laws depends on several factors, including the location of the deceased's assets, their residence at the time of death, and the specific legal frameworks of the involved countries. Applicable laws in dual citizenship inheritance. 1. Domicile and residence. The primary determinant in inheritance law is usually the deceased's domicile or habitual residence. This is the place where the person had their permanent home. The laws of the country of domicile typically govern the inheritance of movable assets, such as bank accounts and personal belongings. 2. Location of assets. Immovable assets, such as real estate, are generally governed by the laws of the country where they are located. This means that if a dual citizen owns property in two different countries, each property will be subject to the laws of the respective country. 3. Nationality. In some countries, nationality can play a role in determining which inheritance laws apply. For instance, certain countries may assert jurisdiction over the inheritance of their nationals, regardless of where they reside or where their assets are located. Conflict of laws in inheritance. In cases where multiple jurisdictions are involved, conflicts of laws can arise. These conflicts can complicate the distribution of assets and lead to legal disputes among heirs. To mitigate these issues, many countries have entered into international agreements or treaties that establish rules for resolving such conflicts. Choosing the governing law. Under certain circumstances, a dual citizen may have the option to choose which country's laws will govern their inheritance. This choice can be made through a legal document known as a Ponzi choice of law clause or Kani testamentary disposition. 1. European Union regulations. In the European Union, for example, the EU Succession Regulation, Regulation EU No. 650/2012, allows individuals to choose the law of their nationality to govern their entire succession. This choice must be explicitly stated in their will or a similar legal document. 2. Other jurisdictions. Outside the EU, the availability and recognition of such a choice depend on the local laws of the countries involved. Some countries may not recognize the choice of a foreign law, while others may allow it under specific conditions. Practical steps for dual citizens. For dual citizens seeking to ensure clarity in the distribution of their estate, here are some practical steps. 1. Consult legal experts. It is crucial to seek advice from legal experts in both countries of citizenship. They can provide guidance on the applicable laws and help draft a will that aligns with the legal requirements of both jurisdictions. 2. Draft a clear will. A well-drafted will that explicitly states the desired governing law and addresses the distribution of both movable and immovable assets can prevent legal complications. 3. Review and update regularly. Regularly reviewing and updating the will to reflect any changes in personal circumstances or legal developments is essential. 4. Consider international treaties. Be aware of any international treaties or agreements between the countries of citizenship that may affect inheritance laws.